Okay. Good morning, ladies and gentlemen. Today is Friday, March 14th, 2025, and it is approximately 10:19 a.m. I'm Melanie Bean. I'm the Vice Chair of the Domestic Violence State Coordinating Council. And as you know, Brooke Hypenthal, formerly of the Attorney General's office, has resigned her position as chair because she relocated to Arizona to pursue other professional opportunities. As vice chair, I'll be presiding over our meetings until a chair has been elected in our 2025 meeting. We apologize to the members and our guests who were with us previously. We attempted to convene this meeting around 10 a.m. and unfortunately, some bad actors entered the room and hijacked our meeting. So we had to end that meeting and reconvene here. I've heard of that occurring because this is a public meeting. And guests are invited. I guess we can't always control bad actors. And so we do apologize for, unfortunately, what we all had to see. But I want to welcome you to the quarterly meeting of the Domestic Violence State Coordinating Council. As I stated, it is open to the public. We welcome our newest member, Assistant General Katie Neff of the Attorney General's Office. And General Neff was previously with us and had introduced herself. I do not see that she has re-entered the room. And if she is not here, we will move forward with welcoming the remainder of our guests, many of whom have rejoined us in this meeting. Their information is in the chat section. As a matter of course, I guess we'll need to recall the roll. Madam Secretary, could you proceed with the roll call?
Yes, ma'am. Thank you. Good morning again, everyone. Vice Chair, Acting Chair Bean, Melanie Bean.
Here.
Thank you. Councilmember Castillo Young. Councilmember Castillo Young. Councilmember Curtis. Councilmember Chelsea Curtis. Councilmember Dalton. Councilmember Angelita Dalton. Councilmember Davis Durisha. Councilmember Durisha Davis. Councilmember Davis Sarah.
I'm here.
Thank you. Councilmember Frog.
Here.
Thank you. Councilmember Jones, Sue Jones. Councilmember Littleton. Councilmember Mary Littleton. Councilmember McDevitt. Councilmember Regina McDevitt. Councilmember McMillan. Councilmember Greg McMillan. Councilmember Miller, Stacy Miller.
Here.
Thank you. Councilmember Neff. Councilmember Katie Neff. Councilmember Parker. Councilmember Ashley Parker. Councilmember Reynolds. Councilmember D. Reynolds. Councilmember Russell. Councilmember Ray Russell. Councilmember Scott.
Here.
Thank you. Councilmember Tate, Elena Tate is out sick today. Councilmember Van. Councilmember Bobby Van. Councilmember Bess.
Here.
Thank you. Councilmember Wally. Councilmember Paige Wally. Councilmember Castillo Young.
Hey, I'm here.
Okay, very good. Thank you. At this point, Madam Chair, it does not appear that we have a quorum.
All right. We do not have a quorum. I was looking at the agenda to see if there was anything today that would need a vote, but anything that would need a vote would need to be paused till the next meeting then. Would that be accurate?
That is correct, yes. And we do have voting items on the agenda for today.
We have no voting items on the agenda, correct?
We do.
Okay,
We
all
do
right.
have voting.
All right, so I will move on to the legislative update. This morning we have Heather Michelle. She's the lobbyist for the Tennessee Coalition to End the Domestic and Sexual Violence, who's been invited by Secretary Fox to give us update on bills that are relevant to domestic or sexual violence, including a new bill impacting BIPs and the DVSCC. So please join me in welcoming Heather Michelle. I've worked with Heather in some other capacities and have been a part of conferences where she has been a speaker. So Heather is a great wealth of knowledge and does a really good job for those who may not have personal experience with her. I hope that you get an opportunity to personally meet her one day. So Heather, I will turn the meeting over to you at this moment.
Thank you, Melanie, and thank you, Tina, for inviting me. Hello, everyone. It's nice to be with you all. I know we're getting a little bit of a late start, so I'm going to go over one bill that directly impacts the DVSCC, BIPs, and the AOC. I'm going to just go through it section by section to let you know the update on this. This bill, House Bill 661, was previously sent out by Jennifer and Tina, I believe, to you all or to some of you to look at this. It is filed by Representative White, Chairman White in the House, and Senator Brent Taylor in the Senate. Both of these are Memphis, West Tennessee legislators, and I have reached out to inquire as to whether this was coming from their district, if there was a specific case that inspired this or a constituent. I have yet to get a response from their offices, but we'll be following up with them. So this bill is titled the Comprehensive Assault Crime Intervention Act. And in Section 2, it dives right in to the alternative sentencing for 39, which is domestic assault. And this makes some pretty significant changes to current code. Let me just get our code pulled up here, 39-13-111. And it says that the sentencing judge, it changes it from may to shall. The sentencing judge shall direct the defendant to complete an available counseling program that addresses violence and control issues, included but not limited to batterers intervention programs that meet the requirements of 38-12-110 and has been certified by the Domestic Violence State Coordinating Council. So this is changing the may to a shall, and it still has the option of counseling programs, not limited to BIPs, but can include BIPs. It does pull out the drug and alcohol treatment option and just adds it to clean up the code a little bit so they can also still be directed to drug and alcohol treatment programs. That is a may. So the shall now pertains to counseling or BIPs. So anybody convicted under domestic assault will no longer have the option to be sentenced to these things. This bill would require them to be sentenced to counseling that addresses violence and control issues or not limited to BIPs, so BIPs included in that. So then we go to Section 4, and this is a new subsection that regulates the BIP statute, which is 38-12-110. And if anybody has any questions at any point in time, just holler and I will stop talking. 38-12, Domestic Violence State Coordinating Council, 110. This is the only bill that opens up the DVSCC code that I see opening up 38-12. And what this is saying, this is adding in a new subsection that will require the council to prescribe terms for batterers intervention programs. And these terms include a minimum of 26-week program to not exceed more than 48-hour weeks, or 26-week programs to not exceed 48-week programs. Each meeting must be at least 3 hours long, and the ratio of participants in these programs must not be more than 6 participants to 1 counselor. And these programs cannot include more than 10 participants. So I'm not sure how this is impacting. Those regulations would impact the work being done with our BIP programs across the state. Just wanted to highlight this section with the regulations. And I know there was some emails that went out asking about if we could align this with current standards and practices. So that was part of the questions that I asked the offices when I had reached out. So section 4 is just regulating those meetings. Section 5 goes into additional punishments. Section 6, 3913-101 is the assault code. And this says, in addition to any other punishment that may be imposed for a violation of this section, the sentencing judge shall require the defendant to attend individual counseling programs addressing violence control issues, including a batterer's intervention program that has been certified by the Domestic Violence State Coordinating Council. So again, just changing the requirements in these alternative sentencing parts of the code to require counseling and BIPs. And so with that requirement on assault under 3913-101, I'm not sure how you all are feeling about this, and Stacy and others are more familiar with our BIP capacity across the state, but if they require this amongst everybody convicted of an assault crime, I'm not sure what our capacity level looks like or if there's any concerns with that.
Did you
Thank
say
you.
that this is assault, all assaults, or just domestic assault?
So 3913-101 is assault. And it is adding a new subsection that says, in addition to any other punishment that may be imposed for a violation of this subsection. Let me just double check because I'm on right. 3913-101, I think just opens up assault.
Yeah, 111 is domestic assault. So
Yeah. So all
that's
assault.
interesting. That's curious, but
I agree,
Seems broad.
Sarah. Yeah, I agree, Sarah. It seems like that maybe the drafting code, I don't know if that was intentional or if it was, just an error. That if the drafter of the bill intended for that to be under the domestic assault code.
I mean,
Not
I've
that-
never, this is my concern with that. I don't know that this would play out in real life, but we have people that don't want to plead to domestic assault because of the specific penalties, the enhancements, the gun ban, and they often will try to leverage a plea to an assault as opposed to a domestic assault to avoid those punishments. And so we rarely ever do that. I'm sure you know what I'm talking about, because we want people to have that domestic conviction. I can't imagine a scenario in which I would send a person with a just regular misdemeanor assault conviction to take a BIP. I mean, the BIP is specifically for. I mean, we talk to victims a lot. I talk to victims a lot about this, that, when we have people go to BIPs, this is specifically for domestic violence. It's for issues with power control. It's not just anger management, which is something you can send people to. I mean, I guess this is still an option. And maybe the idea that it's forcing judges to order counseling is not a bad thing. But I kind of agree with you. I think it should have maybe been in 111, regulating 111 and not 101. But that's just my 10 cents.
Yeah, I tend to agree with Sarah, and I'm not for sure if this legislation, I know Heather said that she reached out to the sponsors, but I don't know if this legislation is being driven because maybe there are sections of the state where maybe there is a lot of negotiations and pleas allowed to allow a plea under regular assault versus domestic assault in order to avoid those requirements that are may now versus a shall. So, maybe that was one of the driving forces. I appreciate Heather reaching out and trying to get some more information on that. Any other comments or discussion from members of the committee? Would like to weigh in on the legislative update that's been provided by Heather?
As a judge, I can see that not necessarily being supported because, like you said, the batterer's intervention is targeted for a domestic assault, and so I'm worried that it's going to affect support if it's such blanket legislation and not geared specifically towards what those programs were originally created to address. I could see that being an issue, especially if it's an assault and two people get in a fight, after drinking all night and there's absolutely no domestic situation involved. It really, I could see the bench not necessarily being supportive of it, because that, an assault does not necessarily an isolated event does not necessarily warrant a 26-week program. That's also
Right.
very costly. So it concerns me that it might affect the support of the bill when it's not. The intent might have been kind of confused.
Well, I just want to point out, I do think it was the intent of the sponsor to include it under domestic assault, because Section 2 opens up 3913-111, domestic assault specifically. So Section 2 looks at domestic assault, and then they add in another section under 101, 3812 for regular, I'm sorry, 3913-101 for regular assault. So they specifically added the may to shall in both parts of the code. And then they do put that in. You make a good point, Judge Scott, about the 26-week. It's a minimum of 26 weeks at this point. So yeah, maybe an isolated event. I wrote it down as you were saying. It doesn't warrant a 26-week program. I do want to mention the final part of the bill, because it does a couple things. The other part of the bill, Section 7, is the continuing education part, and I've been messaging with Michelle Consiglio-Young, who's on the call with the AOC about this, but this requires the DVSCC to establish a policy regarding and providing continuing education curriculum around domestic violence assault, and to all judges and court personnel through the state. And I think the continuing education must be for 12 hours per year. And so I know that's going to be an additional burden, 12 hours of continuing education. And Michelle, did you say there already is a domestic violence continuing education requirement for judges?
Yes. Hi, everyone. So Michelle Consiglio-Young, AOC. We have also reached out on this bill on the various sections. We're trying to get a meeting with these House sponsors. It's not running in the Senate yet, but Heather's right. So there is already a requirement in 366702 that was added a few years ago, maybe 2 years ago, requiring 2 hours of domestic violence training for the judges, which we had worked with the sponsors on that back when that was proposed. So we have that, and typically there's more than that, available to the judges, more than the 2 hours. We are going to talk to the sponsor about it, because 12 hours on any given topic is a lot for us to provide to judges. We just do not have that much time, in front of them, even though we know that it's a worthy topic. It's just that's a tall order. So we're talking to them about that, and then the same issues of the requirement for the sentencing judge. We've also would like to talk to those sponsors about. So we're kind of in the same boat as Heather on this, just trying to get a little bit more information. It does appear that it came out of Shelby County, so we'll just see if maybe this is something specific that they're trying to address there, and get with the sponsors. And we've worked with the House and Senate sponsor before. I think both of us, will probably have good conversations with them on it.
Thank you,
Thank
Michelle. Thank you, Heather. Heather and Michelle, it might, based upon the discussion that we've heard in the meeting, perhaps it would be appropriate to reach out to those sponsors and ask them perhaps for some more information or a reconsideration perhaps on that may versus shall language under 101. Maybe it needs to be an option that it remains may under 101, but certainly be a shall under 111. Sarah may have some additional comments on that as well, or some other members, but maybe that be part of the discussions that's had with those sponsors. Any other discussion on this topic?
I think that's appropriate, what you suggested, Melanie. I really, I would be interested to hear any argument in favor of putting it as shall under an assault. And, you could put individual counseling as shall under 101 if you wanted to, or some type of counseling, but not the batter's intervention, I wouldn't think. And, one more thing I would say is I sometimes encounter with judges, especially if I have a case that's been pending for a really long time and we finally get to trial and we have a trial and there's a conviction and the parties are not together and they haven't had any problems, the judges sometimes can be a little reticent to order a bit because they're like, well, these people aren't together, there haven't been any problems, that's too long of a program, so I don't want to order it. And I mean, those scenarios I think are, that's a type of situation where I think this legislation would be beneficial because it's not like the problem goes away. And I sometimes get very frustrated myself with judges not ordering BIPs when I really think they should be ordered because judges think that they're too hard on offenders because it's too long of a program. And maybe that is the issue that they're trying to solve in Shelby County. I don't know. Like you said, perhaps we find out a little more information, see if we can find out what the reasoning is, what they're thinking, and maybe they can tweak it a little bit.
Thank you.
Yeah.
Yes, great comments. I do think that the legislature is trying to end session a little bit early this year. I know they're pushing through committees right now. I think they're trying to end session somewhere in early April in order, based upon some things that are occurring in federal court. So I don't know if that's going to cause this to get bumped or not, or how fast they're going to move, Heather. But you and Michelle just keep us posted, or anything that any of us can do outside of the meetings, just let us know, okay?
Melanie, I
No
have a
further
question.
discussion or comments on the legislative. Michelle, go.
Sorry, so I had a question for Stacy really quick. And I see her hand up. I think she was gonna want to talk to you, but
I apologize. I didn't see her hand up.
no, that's okay. And she can maybe address this while she's talking. Are there enough programs out there to accommodate this? I guess that would be the other question. Because even if you add the shall to the domestic assault section, I mean, is there enough resources to provide that type of course and counseling if this was ordered, if it was a shall?
Well, this is one of the things that I wanted to raise my hand and address. In that statute, it talks about it needing to be 3 hours long, needs to have a ratio of 6 to 1 facilitator. Some of that background was pulled from the A&D component from IOP. You do 3 hours a day, 3 times a week. So I think they got some of maybe the therapeutic side from another type of intervention on the substance abuse side. One of the biggest, and I would say probably the only sometimes issue with getting judges to order better intervention is the fact that the price. We're very competitive. We're very generous with our people. We charge $20 a session. And we work with our participants. Right now, the state standards line it up that we're not allowed to have more than 15 on the roster or in attendance. We keep it under 16 attendees. If we divide that to keep it to the 1:6 ratio, and we extend the length of the program weekly, you're going to drive up the cost even more to the program. The facilitators are going to do twice the work. And with that being said, you're going to have to pay the facilitators for the extra work, and that's going to be passed down to the participants. When the cost goes up on the program, your judges are going to be less likely to order that, especially in small rural areas where the average family household income is much lower than your urban cities. I certainly understand Senator Taylor's drive to get a hold of the crime in Memphis. Tennessee is continually, we know, in the top 10 of women killed by their domestic partner. If we take out the homicides in Shelby County from the rest of the state, the numbers would dramatically decrease and Tennessee would fall out of the top 10 rapidly. And so I know that this is a desperation on their behalf and their legislators. They had a call from the governor that says, hey, you've got to get a hold of what's going on in Shelby County. So I know that some of this legislation that's coming out is out of desperation to control the crime that's there and to protect society. But I do feel like if you increase the price, you're going to have less people actually order to the program. Now, if the bill states that you've got to order them to it, you're just going to have more people abscond. You're going to have more people not show up. But most importantly, before you even get to that, you're just going to have, like what Sarah said earlier, you're going to have less people pleading. They're not going to plea. And then they're going to pressure the victims to not prosecute. And so then we set the movement back 15 years by doing that. I am 100% on board. Heather, anything that you need, if we need to sit down and talk with Brett, we can do that. I've got some connections to him too. So if we can do any of that to get that done, just add me to the list.
Thank you for that feedback, Stacy. Any other comments or discussion on the legislative update? Okay, seeing none, we'll move on to the executive committee report. Yesterday, the executive committee met for a brief moment. We were disrupted by a personal obligation that I had with my son who had surgery. We just discussed briefly the meeting minutes that we had received from the other committees, and there was no additional information that was discussed as to the executive committee meeting at this point. Secretary Fox, is there anything that you would add to that?
No, ma'am. Thank you.
All right, we'll move on to the certification and monitoring review. Stacy Miller, committee chair. It's my understanding they met this morning in a separate Zoom, and so we'll now hear from Stacy.
Thank you, Madam Chair. Ms. Fox, do we now have a quorum? I've seen some others enter the room. Do we have a quorum at this point?
Yes, ma'am, we do have a quorum. And Madam Chair, I did send you a message that we do have a quorum. So thank you. Thank you, Stacy.
Yes, ma'am.
Thank you.
So with that being said, I've got several programs to address, so I do want to go through them rapidly. I'm going to start the first one. Right now, I also wanted to address that we have 24 state certified batter intervention programs currently across the state. They serve only 62 of our counties. We will have an announcement towards the end of my report to address some potential new programs, but we're also going to have to address some programs that we no longer have. But currently we have 24 current state certified programs to serve the county. We have 5 programs that we will be looking at today for recertification. The first is Community Probation Services in McMinnville. They serve Warren, Grundy, Claiborne, Granger, Hamilton, Hamblin, Hancock, Hawkins, and Union counties.
Ms. Miller, if we can, please, I apologize for interrupting you. If we can start with Lena's report first, please, and then we will circle back to you. Thank you.
Okay.
So we want to
Lena, I will hand it over to you.
Okay. We want to start with Tennessee Correctional Services West. I'm reading this because this is Stacy's program and it's in Jackson. And I just want to say that this is a model program. Top-notch program, in the words of Tina, it's just the example of programs. And I'm not saying that because Stacy's here and she's the chair. She's just amazing. And I've learned so much from her, and I know that everyone else has. And thank you, Stacy, for what you do, and we appreciate you. So they serve Benton, Carroll, Crockett, Decatur, Gibson, Haywood, Henderson, Hardin, Madison, McNairy, Tipton, Fayette, and Lauderdale counties. They have submitted the necessary documents, including the $200 payment for recertification. We have reviewed the paperwork and we've discussed this program. It was monitored virtually on February 11th by Tina Fox. After the discussion with the committee, we agreed to recommend Tennessee Correctional Services West for recertification. So I guess we need a motion.
I make a motion to recertify.
Second.
If you can please
Melanie
identify
Bean.
yourselves whenever you're making a motion in second, please. Thank you.
Second by Melanie Bean. The motion was made by Kendra Reeves.
Correct.
All in favor?
Aye.
Any
Sarah.
opposed?
Madam Chair, I'm sorry, Madam Chair, we do have to do an official roll call.
Okay, we'll do an official roll call on
Yes.
the vote.
Okay, all right. Vice Chair Bean, Acting Chair Bean,
Aye.
Councilmember Consteelio Young,
Aye.
Councilmember Derisha Davis, Councilmember Derisha Davis.
She's putting her hand up as aye.
Okay, very good. Thank you, because I can't see it. Councilmember Davis, Sarah Davis.
Aye.
Councilmember Frog.
Aye.
Very good. Thank you. Councilmember Miller, you are going to recuse yourself. Councilmember Neff.
Aye.
Thank you. Councilmember Parker.
Aye.
Councilmember Ashley Parker.
Aye.
Thank you. Councilmember Reeves.
Aye.
Thank you. Councilmember Scott.
Aye.
Councilmember Vess.
Aye.
And Councilmember Fox. Aye. Madam Chair, that concludes the official roll call for Tennessee Correctional Services West.
Wonderful. Okay. And at this point, Lana, do you have anything else that you need to cover as a part of this committee, or would you like to turn it back over to Stacy at this point?
Turn it back over to Stacy.
Thank you, Stacy. If you would continue, please.
Thank you, Madam Chair. Thank you, Lana. And thank you, Ms. Fox. Okay, so we're going to start with the other programs, and I thank you everyone for your confidence in me and for the words that you shared, Lana. The first program I want to address is the Community Probation Services of McMinnville. They serve Warren, Grundy, Claiborne, Granger, Hamilton, Hancock, Hawkins, and Union counties. They've submitted their necessary paperwork, including the $200 payment for recertification. The committee reviewed their paperwork and we discussed their program. The program was monitored virtually on 2/11 by Tina Fox and Judge Greg McMillan. After the discussion, the committee agreed to recommend Community Probation Services for recertification, and we were requesting a motion to do so.
This is Lena Frog, and I make a motion to recertify Community Probation Services.
This is Kendra Reeves. I second that motion.
We have a motion and a second properly. Secretary Fox, would you call the roll?
Yes, ma'am. Thank you, Chair. Chair Bean.
Aye.
Councilmember Castillo Young.
Aye.
Councilmember Derisha Davis.
Aye.
Thank you. Councilmember Sarah Davis.
Aye.
Councilmember Lena Frog.
Aye.
Thank you. Councilmember Miller.
Aye.
Thank you. Councilmember Neff.
Aye.
Thank you. Councilmember Parker.
Aye.
Thank you. Councilmember Reeves.
Aye.
Thank you. Councilmember Scott.
Aye.
Thank you. Councilmember Vess.
Aye.
Thank you. Councilmember Fox. Aye. Madam Chair, that concludes the official roll call for Community Probation Services.
All right, so that motion carries. And Ms. Miller?
All right, our next program is Intervention Academy in Oneida, serving Scott County. They have submitted all necessary documents, including the $200 payment for recertification. The committee reviewed the paperwork and discussed the program. The program was virtually monitored on 2/22/25 by myself. And after discussion, the committee agreed to recommend Intervention Academy in Oneida for recertification, and we are requesting a motion to do so.
This is Lena Frog, and I make a motion to recertify Intervention Academy.
This is Kendra Reeves. I second that motion.
We have a motion and a proper second. Madam Secretary, would you please call the roll?
Yes, ma'am. Thank you. Chair Bean.
Aye.
Thank you. Councilmember Castillo Young.
Aye.
Councilmember Davis, Derisha.
Aye.
Thank you. Councilmember Davis, Sarah.
Aye.
Councilmember Frog.
Aye.
Thank you. Councilmember Miller.
Aye.
Councilmember Neff.
Aye.
Thank you. Councilmember Parker.
Aye.
Thank you. Councilmember Reeves.
Aye.
Thank you. Councilmember Scott.
Aye.
Thank you. Councilmember Vess.
Aye.
Thank you. Councilmember Fox. Aye. Madam Chair, that concludes the roll call for Intervention Academy.
Thank you, Madam Secretary. That motion carries. Secretary, Chair Millard, is there any additional business of the committee?
Yes, ma'am. Our next program is Stepping Out Inc. in Morristown. They serve Hamlin, Jefferson, Granger, Cock, and Greene counties. They have submitted all necessary documents, including the 200 payment for certification. The committee has reviewed their paperwork and discussed the program. The program was virtually monitored on March 6th by myself, Judge Greg McMillan, and Tina Fox. After discussion, the committee has agreed to recommend stepping out for recertification, and we are requesting a motion to do so.
This is Lena Frog, and I make the motion to recertify stepping out.
This is Kendra Reeves. I second that motion.
I have a motion and a proper second. Madam Secretary, would you take the vote for the motion?
Yes, ma'am. Thank you. Chair Bean.
Aye.
Thank you. Councilmember Castillo Young.
Aye.
Thank you. Councilmember Derisha Davis.
Aye.
Thank you. Councilmember Sarah Davis.
Aye.
Thank you. Councilmember Frog.
Aye.
Thank you. Councilmember Miller.
Aye.
Thank you. Councilmember Neff.
Aye.
Thank you. Councilmember Parker.
Aye.
Thank you. Councilmember Reeves.
Aye.
Thank you. Councilmember Scott.
Aye.
Thank you. Councilmember Vess.
Aye.
Thank you. Councilmember Fox. Aye. Madam Chair, that concludes the roll call for that particular organization. Thank you.
Thank you, Madam Secretary. The motion carries. Any additional business? Chair Miller.
Yes, Madam Chair. Our next program that we want to address is BIPS at Successful Survivors. Our last meeting, they were granted a extension. They are in Nashville. They serve Davidson County. They have not submitted the necessary documents, but they have paid the $200 for their recertification. They have requested a 3-month extension. Partial paperwork has been submitted, but not in its entirety. The program was monitored virtually on November 7th by Ms. Fox, and after discussion, we have agreed to give them 1 extension with the caveat that the paperwork must be turned in the next 30 days to Ms. Fox, and we are requesting a motion to give them that extension.
Sorry, this is Lena Frog. I make that motion to extend that for 3 months, and then also with a letter letting them know that they have 3 months and we need that information within 30 days.
This is Kendra Reeves. I second that motion.
Motion and a proper second. Secretary, Madam Secretary, would you please take a vote on the motion?
Yes, ma'am. Thank you. Chair Bean.
Aye.
Thank you. Councilmember Castillo Young.
Aye.
Thank you. Councilmember Derisha Davis.
Aye.
Thank you. Councilmember Sarah Davis.
Aye.
Thank you. Councilmember Frog.
Aye.
Thank you. Councilmember Miller.
Aye.
Thank you. Councilmember Neff.
Aye.
Thank you. Councilmember Parker.
Aye.
Thank you. Councilmember Reeves.
Aye.
Thank you. Councilmember Scott.
Aye.
Thank you. Councilmember Vess.
Aye.
Thank you. Councilmember Fox. Aye. Madam Chair, that concludes the roll call for BIPS at Successful Survivors.
Based upon the vote, the motion carries. Any additional business? Chair Miller on the Certification and Monitoring Review Committee.
Yes, Madam Chair, we'll have old business and new business now. I'm going to touch base on our old business. Is previously brought to the council's attention on September 13th. Percy Ford was arrested June 20th, 2024 for 2 counts of violation of order protection in Davidson County. He is the program director of Lighthouse Correctional Counseling and Mental Health Services, servicing Davidson and Rutherford counties. The Davidson County General Sessions Court and the probation office have not conducted any business with Mr. Ford since the arrest. We discussed this matter in our certification and monitoring committee today, and we have agreed that he should be removed from our certified list, and we are requesting a motion from the council for him to be removed from our certified list of batterer intervention programs.
This is Lena Frog, and I make that motion.
This is Kendra Reeves, and I second that motion.
We have a motion on the floor and a proper second. Madam Secretary, could you please take a vote for the motion?
Yes, ma'am. Thank you. Chair Bean.
Aye.
Thank you. Councilmember Castillo Young.
Aye.
Thank you. Councilmember Derisha Davis.
Aye.
Thank you. Councilmember Sarah Davis.
Aye.
Thank you. Councilmember Frog.
Aye.
Thank you. Councilmember Miller.
Aye.
Thank you. Councilmember Neff.
Aye.
Thank you. Councilmember Parker.
Aye.
Thank you. Councilmember Reeves.
Aye.
Thank you. Councilmember Scott.
Aye.
Thank you. Councilmember Vest.
Aye.
Thank you. Councilmember Fox, aye. Madam Chair, that concludes the official roll call for Lighthouse. not
Based
being
upon-
certified.
Based upon the vote, the motion carries.
Thank you, Madam Chair. Our new business, we have several new potential program directors that have reached out to Ms. Fox regarding interest in starting BIPs in their area. She has spoken to and been working with the DUI Educational Center in Rutherford County, Amani Behavioral Health in Clarksville, serving Montgomery County, and the court-ordered classes in Jacksboro, serving Campbell County. In fact, 4 of the staff and members of the DUI Educational Center have already completed the Emerge BIPS training February 5th through the 25th. So we have, of 25. We have potential 3 new programs coming into the area. And the DUI Education Center in Rutherford County will be serving 50 counties in Middle and East Tennessee. So that's going to really fill in some gaps there where we have lost some programs. So Ms. Fox has done an excellent job of giving them the technical assistance that they need. And all 3 of those programs have really shown to be aspiring when working with Ms. Fox. So thank you, Ms. Fox, for working with those programs and all that you're doing to bring them on board. On January 25th, Ms. Fox met with Judge Joel Perry and ADA William Dyer of Robertson County. They had expressed prior interest of wanting a BIP in their area, and they wanted to add batterer intervention to Springfield. JC Commando of Alternative Counseling Solutions in Nashville has agreed to serve Robertson County, so we have added another county to the service area to cover that. I spoke in our committee earlier today. JC is one of our referral partners that our company actually uses. He's bilingual. He does offer some programs that we do not, and we have had wonderful success with him over the last 2 years with the programs that he offers in East Tennessee and Middle Tennessee. So we are really excited for that new program to start in Robertson County. The sad news is the following programs have decided to close, and that's Avalon Center, the Abuse Intervention Program for Men in Crossville, serving Bledsoe, Cumberland, Fentress, and Morgan, Van Buren, Ray, and Roane counties. Avalon, as you may recall, they are one of our pilot programs for data that's being sent to the TBI. And so they had lost a long-term and now they are no longer offering BIP, and that program is closing. Followed by Mid-South Court Diversion in Memphis, serving Shelby County. That program is also too closing. So
Okay.
programs. So when we work real hard.
I think we lost you for just 1 second, Stacy, but I think you're back.
Okay. When we win programs in and bring programs in, we're losing programs too. And so it goes back to our discussion today that we had over that legislative piece. It's really difficult for these programs in small rural areas to be able to continue to function and to be able to fund their programs. It's hard to train and pay for those facilitators to get the level of training and the certifications that they need. So the last piece of business that we have is the BIPS annual conference. It has a new name. It's the BIPS Professional Development Summit. It's now slated to be held on Friday, May 16th from 8 to 4:30. It's going to be in intervention programs with a focus on program integrity. Ms. Fox and the planning committee have solidified a keynote speaker, Brandy Daly, who is the community response facilitator for Arkansas Coalition Against Domestic Violence in Little Rock. I was in Michigan at the BIP conference last November and had the privilege of meeting Brandy. She's a phenomenal presenter, absolutely just all around excellent presenter in person and advocate. And I'm really excited about having her with us at our conference this year. With that being said, Madam Chair, that's all the information that I have from our committee, and I will give the meeting back to you. Thank you.
Thank you, Stacy, for the report, and to your committee for the work that is being done on victim safety and offender accountability. Does anyone have any additional questions for the Certification and Monitoring Review Committee? Hearing none, seeing no hands raised, we'll move on to emerging issues and orders of protection. The committee chair is Michelle Consiglio Young. The Emerging Issues and Orders of Protection Committee also met this morning in a separate Zoom meeting, and we will now hear from Chair Michelle Consiglio Young. Michelle?
Hello, everybody. Thank you, Chair Bean. I appreciate that. And okay, so we did meet this morning at 9. We had all members of our committee present. We did not have any action items on our agenda for today. I did give a brief update on some previous changes that we had discussed and approved on the bail order form for abuse cases. We were going to issue that via the AOC in January, but we had seen that there were some possible legislative changes in the pipeline, and after discussing it internally, we decided to wait and put all any changes to any order protection or related form, just do that all at the same time and issue that after the legislative session. So we just had a brief hold on that, and the committee understood and seemed fine with that update. And then we did go over a few pending legislative items. Obviously, Michelle addressed one of them. There were a couple others that are just pending that would impact the order protection forms and other issues. So we just went over that for awareness, but obviously we would address any of those changes in our June meeting prior to issuing any forms, official form changes out to the judges and court personnel. And then also address that we had received an inquiry from the board president of the Memphis and Shelby County Domestic Violence Council regarding training, which does relate a little bit back to the bill that Heather brought up. So I just brought that up for awareness. And there was a point, and I do plan to bring this up with the sponsors of that legislation, but there was a request for specific training for the judicial commissioners, which is something that the AOC does not do. We do not control the training for judicial commissioners. They have their own association, and I think that that's a valid point to bring up, because some counties do use judicial commissioners to address orders of protection. So I think that's something we can discuss with the sponsors of the legislation. And also we, the AOC, will reach out to the executive director of the judicial commissioners so that they're aware of that request. But it was all just informational items. Again, nothing for a vote or action at this time. And we will just wait till June to see if we have any changes on our forms.
Thank you, Michelle. Thank you for your report from the committee. And does anyone have any questions of the committee? Hearing none and seeing no hands raised, we will move on to the training and education report. Either Ms. Tate or Ms. Payne, are either of you with us?
I'm Ashley Parker. I'm on the committee. I'm here.
Okay, I'm sorry. Ashley,
That's okay.
yes, I see. I'm sorry. I had a note here. We will now hear from and Ashley Parker it said Payne and then Parker. So I apologize, Ms. Parker. Would you please proceed with providing us with an update?
Yes. So it appears that there was 3 trainings. Ms. Fox, do you want to share the trainings?
Since there were only 3, we can just roll through those 3.
Okay, I can do that. It looks like there were 3 trainings, one on 225 and 2 on 226. One was a criminal law update, one was a firearms and domestic violence, and the other was an elders and domestic violence, and there was a total of 450 attendees. I think that's all we have.
All right, that's wonderful. Thank you, Ashley, for the report, and to your committee for the work that's being done on training and education. Does anyone have any further questions for this committee? Hearing none, seeing none, we'll move to the Standards and Rules Committee with Chair Sarah Davis. The Standards and Rules Committee met January 22nd, 2025 via Zoom. And we'll now hear from Sarah.
So can I ask a question? Tina, I noticed that the minutes that were sent were from the meeting in November. Have we already gone over those with the council?
Yes, we have.
Okay.
Thank
All
you.
right. So the committee met on the Standards and Rules Committee met on January 22nd of 2025. Tina Fox was there, myself, Stacy Miller, Felix Vest, and Heather Herman. Our Brooke Huppenthal was not there because, as has been previously stated, she has left the council because she's moving. And I just want to give her a shout out in absentia because she really helped us a lot on working on this committee up until the point that we're pretty much at right now, which is, yes, thank you, which is having she's the one that edited all the edits and she made a lot of great suggestions, as well as did all the committee members. But I just want to thank her for all she did to help us. So this will probably be our last report on the Standards and Rules Committee for right now, because after this, we're hoping to give it to the rest of the council for review. Some additional items that we tweaked on the standards and rules are as follows. We started with a conversation that we had from the previous meeting where we had some concerns about saying that, a successful completion had been done of a batter's intervention program, or a graduation had been completed with the batter's intervention. And I think the concerns that people had is that, you can't like cure people of being a batter necessarily. And we didn't want to broadcast or make it seem as if, successful completion means you're done and you're perfect and you can't fall off the wagon and, need more assistance later. So we wanted to change the language so that it was more that the program was completed as opposed to a successful completion, or the offender completed it as mandated. So we added that language and kind of changed that and put that into the standards and rules. Then we also just made something we kind of circled back around to from our initial beginning with the Standards and Rules Committee, was just making sure that the language was inclusive to all types of battering, including LGBTQ batters, such that, we weren't always referring to, batters as being male necessarily, and that we were giving options for treatment for people that were not necessarily male batters. So we changed the language to allow placement for non-traditional batters and batters intervention programs. And also we were hoping to make it so that we could get more facilitators with experience with these communities. And so we added that into the standards and rules, and that was approved by the committee. Also, a great suggestion was made by Stacy Miller, who again is always very helpful with this committee, that in her wisdom, she felt like there was some other types of programs, curriculums that were available nationwide that were commensurate with some of the curriculums that were approved for BIPs to use. And she mentioned one called River of Cruelty. And so she has some experience with this program, as well as other curriculums that are already allowed through the standards and rules. And I think all of us know that, also just mentioning that she had been shouted out as the, one of the premier programs out there. I think we all trust Stacy that if she says this curriculum is very good and current and trauma informed, that we all would agree that we think it's something that should be allowed to be used by programs. So we added River of Cruelty to the list of curriculums that can be used by batters intervention programs. Also, we talked about the different requirements for certification and recertification and what that looks like for programs, and whether or not the 6-year recertification could be onerous at times for programs, because it requires so much paperwork and resubmitting everything in its entirety. And so I just for those of you that don't necessarily deal with that on a daily basis, and Tina, if you want to pick up where I'm leaving holes in this explanation, feel free. But there's three different types of recertification. There's a short recertification, a full recertification, and a regular recertification. And BIPs right now are being required to have a full recertification every 6 years. And so we had discussed the possibility of not requiring that full onerous recertification for programs unless they were having some type of issue that had been brought to the council or the committee that required them to, get a recertification. So basically, like if you're in good standing, if you're doing your short, recertifications, not the full recertification, if you're doing everything as you're supposed to, we're not going to make you do the full recertification. Now, we also discussed that we didn't know if this was a change that could be made in the standards and rules, because I think, Tina, you might have mentioned that you thought that the recertification requirements were in the BIP rules document as opposed to the standards and rules. And so I had sent you the language that we had discussed, if you recall, by email, and you were going to look into whether or not there was another committee with the council that would address this. So I think where we left off is that we weren't going to be able to change that requirement through the standards and rules document that we had updated, but another committee could do that. And I felt like that was a wise suggestion. I think that everybody would agree that, our goal is to have more well-certified programs. We're not trying to make it any harder than it has to be. So I think we will leave that to another day for another committee. And so another thing we talked about was and I think Stacy also brought this up, is that there were some people that were wanting to facilitate that didn't meet the requirements under the standards and rules for facilitators, whether it be that they didn't have the requisite college degree or number of years of experience. And so we were having people that maybe they have a college degree that wouldn't even have anything related to criminal justice or working in counseling or anything like that, could potentially be a facilitator. But somebody that doesn't have a college degree, that maybe has years of experience working with batterers and victims, that person might not be able to facilitate. And so we kind of decided to tweak the requirements so that we could include people that maybe don't have a college degree, but have a requisite level of experience with the types of communities that we're serving. So we could make sure that we're not excluding really well qualified facilitators just because they don't have a college degree. So previously what it had stated is that in order to be an instructor, you would have to have a college degree, but if you didn't, you could actually be an instructor if you were paired with an instructor who had the college degree and 2 years of experience, either working with the batterers intervention, working with batterers or victims, or working with the criminal justice system or other violent perpetrators. And so then we added another section that would allow that, or if you are not currently paired with a degreed instructor, if you have at least 5 years of previous experience in a batterers intervention as a batterers intervention instructor in a certified program, then you could be an instructor. So basically we just kind of opened it up, but we required at least, we had a little bit of discussion over the number of years of experience that would be required, but we ended up landing on 5 because I think that was kind of a happy medium. It wasn't too many years or too few years. That would kind of make sure that we had qualified people as instructors. So I think that ends all of the final edits that we made to the Standards and Rule Committee. I think all those edits at this point have been put into the standards and rules. They were submitted, I believe, Tina, if I'm not incorrect, in the last email that you sent out.
Yes.
Okay. So
Yes and no, Sarah. So after today's meeting, we will push this out so that the entire council can review for vote at the next meeting in June.
Okay. So just to kind of reiterate what Tina just said, Our goal is to have these new standards and rules enacted by July 1st. So they are going to be pushed out to the council after this meeting. Everyone, please feel free to review them. If there's any other issues that you see that you would like us to work on or change, please, I guess, just kind of send those out to Tina. And Tina, you could send them back to the committee if you want, and we can address that. Also, if there's any changes that we've already discussed that we've made that people do not like or they have a problem with, again, bring those to Tina's attention, and she will address those to the committee. Otherwise, we'll probably be rolling these standards and rules out in July, but please, everybody, take a minute to look at it. I will say it's very long. And it's hard to know where to start with what changes need to be made. But I think we really got to the heart of the changes that did need to be made, and we kind of refreshed and updated it. So have a look. Thank you. That's all that I have.
Thank you, Sarah. And thank you for all the work that you're doing with the Standards and Rules Committee. We'll be ready, hopefully, for a vote on that at our next meeting. And I really want to give a shout out to Sarah as well. I know that Brooke also, as she stated, Brooke was really integral in assisting and preparing those, but Sarah did a really good job also giving us some really good insight and really takes the bull by the horns and gave us some really good insight there. So I appreciate all the work that you're doing, and everyone on that committee. Everyone worked really hard to kind of get these new standards and rules together. And so we look forward to seeing those when Secretary Fox sends those out. Does anyone have any additional questions for this meeting? For this committee? Seeing none, hearing none, we'll move on to any announcements. Secretary Fox, do we have any additional announcements for the purposes of this meeting?
Yes, ma'am, we do, Madam Chair. We'll like to just reiterate, because we've already pushed this information out, that the coalitions and the Sexual Assault Center Day on the Hill event is quickly approaching next Tuesday, March 18th. We are encouraging our council to please, if at all possible, join us for the Day on the Hill. We're asking you to please wear purple to show unity. Purple is the official color of domestic violence. We will meet in the conference room 8C at 9 a.m. Central in Davidson County on next Tuesday. So please, 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 if you can, join us. This is a key opportunity for us as a council to advocate for survivors, educate lawmakers, and show our collective strength as a coalition as well as a council. We had an opportunity to talk with Representative Littleton, who was on the initial call. She did say that she was babysitting, so perhaps that's why she wasn't able to jump on the second call. But we do have a meeting with her at noon on next Tuesday, and she's very excited about the meet and greet. Then the coalition has 3 vacancies coming up effective July 1st. And we will get into more of that in the June's meeting, but definitely want to just pause to thank Stacy Miller, Sarah Davis, and Regina McDevitt for a job well done over these last 8 to 12 years. And so we just want to acknowledge that they will be rolling off. Their terms expire June 30th, and we will be getting new council members from the coalition. Then, as you all know, we have a vacant chair position. The nominating committee will be meeting in May, and we will be pushing out information pertaining to that. But all positions, excluding the secretary and the treasurer position, will be up for nomination. So we need a chair, a vice chair, as well as an assistant secretary, assistant treasurer. And want to just pause and just thank Vice Chair, Acting Chair Melanie Bean for the work that she is doing and is doing on today. We greatly appreciate you stepping in, Vice Chair, Acting Chair Bean, and facilitating today's meeting. And then finally, all minutes, one more time, all minutes from committees are due no later than Friday, March 28th, so that we can satisfy the obligation of the quarterly report that is due to the Office of Criminal Justice Programs by April 15th. Madam Chair, that concludes the announcements. Thank you.
Thank you, Secretary Fox. And we've now reached the public comments portion of our meeting. And as a reminder, all public comments must be submitted to Secretary Tina Fox at least 2 weeks prior to the general body meeting. Madam Secretary, will you please confirm whether or not we have received any public comments, requests within our time of our guidelines?
Yes, ma'am. Thank you, Madam Chair. We have received a request from Becky Bullard within the 2-week period. She sent a letter as a third-party firearms form that she sent out to us, and I think she's still on. So if she wants to address that now, we are here to listen to her concerns. I did send this out to the entire council on Friday 2 weeks ago, so you all should have that readily available. But I think Ms. Bullard is still on, and that's the only public request that we've had, Madam Chair. Thank you.
Thank you, Secretary Fox. So at this time, Becky Bullard, the Deputy Director of Programs at Metro Nashville Office of Family Safety, if you would like to address us with your public comment, we would appreciate receiving that.
Absolutely. Thank you for having me and allowing me to address the letter that was sent to the council. This letter was from, as you can see in the opening paragraph, from over 560 individuals, over 40 organizations that are signing on to the request to the Domestic Violence State Coordinating Council to consider adding information on the third party to the firearms dispossession forms. So there are obviously 2 forms, one for the order of protection for the civil matter and for the domestic violence misdemeanor. And the letter, oh, I'm sorry. Okay. Well, the letter, as you can see, is going through the reasoning to add this information. The individuals who signed the form support the information within the letter that the third party information is really necessary to make the firearms dispossession form functional. As it stands now, the form is not functional and not really implementational in making sure that we are ensuring a lawful means of dispossession. And the reasoning for that is below a little bit in the at the end of the first page and the beginning of the second page. In making sure that we're proving a lawful means, it is not possible to show that there was a lawful means of dispossession without the information for the third party. That third party information is necessary to make sure that this third party is not prohibited from having firearms and that the individual actually is in receipt of those firearms. So some of the points below are that the Domestic Violence State Coordinating Council is empowered to create this change, given that the statute says that the form shall be developed by the council in consultation with the administrative office of the courts. And also just looking at prior precedent that we don't need to have statutory change in order to create forms that have all the functional components in order to meet the laws. So one of the examples there was given the Order of Protection ex parte petition form, for example, has the information for the respondent's employer to ensure service. That respondent's employer is a third party. However, that was not required or laid out in statute, but we do have a line there for that information for the employer. We're simply requesting that there is a similar line and information for that third party so that we can ensure that this form is functional and that we can actually dispossess weapons from people who are prohibited from having them. And then, of course, we gave the example here from Scott County that we've seen coverage for that Scott County courts have already made this change in order to actually make the firearms dispossession process functional. So that is the request. And again, was signed by over 560 individuals, over 40 different agencies throughout the state, many leaders and leadership from law enforcement, from the courts, from nonprofit executive directors, from medical personnel, and then from community members as well, requesting this of the council. Thank you.
Thank you, Ms. Pullard, for that information and for the detailed information that you provided us. That was also circulated by Secretary Fox, and a detailed list of names and organizations that was attached to that. We appreciate it. I would also like to add that I'm aware of other counties that have basically modified their own form. They write in this information. So this suggestion is very well received, and we appreciate the information. Any discussion further on the comment of Ms. Bullard? Seeing no discussion, we will move forward with the balance of our meeting. And Secretary Fox, did I fail to approve the minutes when we began the second part of the meeting?
Yes.
Okay, I noticed that. So the meetings before we move to discussion of our remaining meeting dates, I will go back to page 1 of our agenda. Approval of the minutes from December 4, 2024. The minutes from the last meeting were sent via email by Secretary Fox on March the 3rd, 2025 via email. Are there any corrections? If there are no corrections, those minutes will be approved as distributed. Seeing no corrections being requested, those are approved as distributed. Our remaining meeting dates are Friday, June 6th, Friday, September 5th, and Friday, December the 5th. Are there any questions or comments from the council regarding anything regarding this morning's meeting that anyone would like to address?
Yes, Madam Chair, I think that we may need to have a motion and a vote on the letter that Ms. Bullard mentioned, so that we can officially agree in or disagree with
Okay.
her request. Thank you.
So do we need to submit it to committee, or is that what we need to do? I feel like we can't just necessarily agree to it. We might have to have the committee that deals with the forms change the form, right?
Yeah, it would
Emergent issues in order.
Yeah, it probably needs to be referred to the Emerging Issues and Orders of Protection Committee.
I would make a motion to refer it to that committee, because I think this is a very well taken and well thought out change that does need to be made. I can't see any reason not to make the change, so I would make a motion to refer it to committee.
This is Stacy Miller. I second.
Proper motion is and second is on the table. Madam Secretary, would you take a vote?
Yes, I do have a question prior to the vote, please.
Yes.
Okay, Michelle Castillo-Young, are you still on?
Yes, I'm here.
Okay, so I only have one question. Has this issue been brought up in your committee before?
Yes, it has. We have brought this up. We actually discussed it earlier just because there is pending legislation on this topic. You could definitely, send it to our committee. We would look at it anyway. I will, I think obviously the next meeting will be in June after legislative session. I do think we need to see how the current legislative process pans out. Just so everybody knows, there is the bill that is addressing the dispossession of firearms form and adding the third party on there is Senate Bill 1244, House Bill 1210. So I think that that's important to note because the legislature is taking up this issue. So it may be best, to wait, which would be, June that would happen anyway, until this discussion goes through the legislature and kind of see where that ends up.
Thank you, Michelle, for that information. I'm assuming that if the legislature adopts very similar information that is requested in this letter, then that would essentially potentially resolve that issue, correct?
That's correct. Yeah, if the legislature acts on it, that would address the issue.
By default, of course. All right, perfect. We will go ahead and Ms. Bullard.
Sorry, I can't find my hand raise function, so I just did the traditional hand raise. One thing I will say about the legislative piece is, hopefully that will move through. It is only addressing the civil side of the forms, so not the criminal DV misdemeanor side of the form.
Thank you, Ms. Bullard. All right, with a motion remaining and a proper second, if there's no further discussion on the topic, we'll proceed with a vote. Seeing no further discussion, no further hand raises, Secretary Fox, would you take the roll?
Yes, ma'am. Thank you. Chair Bean.
Aye.
Councilmember Castillo Young.
I'm not sure if I should abstain since it's coming to our committee. So I'll just abstain for now.
Yes, ma'am. Yeah, no worries. Thank you. Councilmember Derisha Davis.
Aye.
Thank you. Councilmember Sarah Davis.
Aye.
Thank you. Councilmember Frog.
Aye.
Thank you. Councilmember Miller.
Aye.
Thank you. Councilmember Neff.
Aye.
Thank you. Councilmember Parker.
Aye.
Thank you. Councilmember Reeves.
Aye.
Thank you. Councilmember Scott had to leave the meeting early. Councilmember Vest.
Aye.
Thank you. Councilmember Fox, I am going to abstain. Madam Chair, that concludes the official roll call.
Thank you, Secretary Fox. Based upon the vote, I believe that motion carries. And if there are no further questions or comments for the council member for the council members at this morning's meeting, I want to thank you for your time this morning and the important work you're all doing for Tennesseans, and the meeting would be officially adjourned.
Thanks, everyone.
Thank you.
Thank you.
Bye.
Bye.